SJC 12898, Commonwealth versus William D. Shakespeare.
Attorney Belger, whenever you're ready. Good morning, Chief Justice Budd and Justices. Amy Belger for Mr. Shakespeare. With me at council table today is trial counsel James N. Greenberg. I'd like to start by discussing the issue raised in my brief about what I allege is the wrongful exclusion of the grand jury testimony of the deceased third-party culprit witness, Mark Edwards. My main argument is under Chambers, where the United States Supreme Court says that when there is evidence that bears upon whether or not the defendant is actually the perpetrator in the case and he wants to defend himself at trial with that evidence, that he has a constitutional right to do so.
Was this case tried before Drayton?
Drayton, yes, no. Okay, so this case was tried in 2016, right? And was Drayton 2014?
I thought this might proceed, because Drayton is our Chambers case, right? And shows you how unique
Drayton
Chambers,
is our Chambers.
it shows you how unique Chambers.
Okay, I'm going to
This is
solve this quickly.
2015.
Yeah, so that's why I was arguing, I was
So
curious.
Drayton's 2015, right?
That's why I was curious as to whether or
Thank
not
you.
that Drayton was raised in this case.
Yes, so I think that my best case is still Chambers, even though we have Drayton, because of the facts here, the specific facts here that are different than what this court dealt with in Drayton. So here we have a third-party culprit witness who is giving false testimony under oath in the grand jury.
So that, I guess, just to stop you there, the point of admitting it at trial would not be for the truth of the matter asserted, but it would be for its falsity.
So he's a third-party culprit, and the evidence that the jury heard was that there were 3 people present when the victim, Marcus Hall, was killed. Marcus Hall.
But I guess my question is, why is this hearsay if the purpose of the admission of the grand jury testimony was to show it was false? Right? Hearsay is usually, as I understand it, admitted for the truth of the matter asserted, and what you're trying to show is that Edwards was lying.
Right. So let me break that down. So I would be looking, or trial counsel was actually looking to admit this was what he testified to in front of the grand jury. So that the truth part comes in, this was the account he gave to the grand jury, right? And then to say, put that in the context of the trial prosecutor told the jury in opening that he was there, Mark Edwards, when the victim was killed. The evidence that the Commonwealth put in was that he was there when Marcus Hall was killed. And from there say, what he testified to falsely in the grand jury is a fact that is true. So it is factually true that he perjured himself in front of the grand jury for what appears to be giving false exculpatory evidence as to himself. So it's not charged as a joint venture. The Commonwealth doesn't proceed that way.
It's kind of a third-party culprit's consciousness of guilt.
Exactly, and trial counsel actually put that on the record for the trial judge to consider. Trial counsel argued, this is the third-party culprit's consciousness of guilt evidence. And there's no reason for Mark Edwards to have lied in the grand jury other than to protect himself. It is established through the video evidence, the times on it, and the Commonwealth's concessions, that he was there. He was physically present.
And all of that was presented to the jury?
It was as best it could be in the sense that,
If this is him?
Yeah.
This is the video, this
Exactly.
is the timeline?
yeah, exactly. So,
So is this cumulative?
oh no, because it's not cumulative, because if he's lying, right, about his presence, he is now suspicious. If I'm a juror, if you're a juror, right, they never heard that he lied to the grand jury about any of this, right? That changes the evidentiary presentation for me as a juror. If I hear that he went into the grand jury and he lied under oath about being there, he lied under oath about how he found out about this.
But
and-
what I'm missing, and forgive me, Attorney Belger, is were the other statements that were introduced that showed he was lying other than the,
No. Oh, I see what you, yeah, so it's not
I didn't ask a
cumulative,
clear
thank you.
question.
It's not cumulative in the sense that they heard nothing about him lying. They heard nothing at all about it. And it is established, I think it's rare, at least in my experience, it's rare, to have a record this clear, where you don't have to infer anything. You can directly see this, that he lied to the grand jury.
In the closing argument, am I correct that this was, the third-party culprit issue was exploited by the defense? It was advocated?
It was absolutely advocated, and there was other evidence that the jury heard about, that was the defense at trial.
Were they advocating that it was this particular person?
Yes, yes.
Because that goes to your Salemi argument.
It does. So, and I can pivot to the Salemi argument if we're
Before you do that,
done. Yeah.
could you apply Clementi in this context? Because the judge relies on Clementi to exclude it, is that right?
Yeah, the judge
So I'm
says
just
it,
looking at the Clementi language. So our rule in both civil and criminal cases is that the prior recorded testimony, blankety blank, where, okay, may be admitted as an exception to the hearsay rule where the prior testimony was given by a person now unavailable in a proceeding addressed to substantially the same issues as the current proceeding, and here's the key language, with reasonable opportunity and similar motivation on the prior occasion for cross-examination of the declarant by the party against whom the testimony is being offered.
right. So I think what's different here is these are lies under oath by a third-party culprit. So the Commonwealth is not going to cross-examine Mark Edwards about this in the grand jury, right?
So do they have a similar, is that standard then met?
I don't believe it is, because I think this is a fundamentally different type of evidence because of what it is. And, the Commonwealth did argue that it is not clear, and I agree with this, that it's not clear that at the time of the grand jury presentation that the Commonwealth knew that Mark Edwards lied to the grand jury. That's not clear, it's not clear. Maybe they knew, because Mark Edwards testifies
Didn't they
weeks.
put out a flyer? I mean, didn't the police officers put out a flyer saying wanted?
Yes.
In connection, and they listed Edwards, right?
Yes,
So they knew that Edwards was on that video.
they did. They knew he was on the
Said
video.
to the grand jury, I wasn't there.
And so he comes in and he testifies, I wasn't there, and
So the Commonwealth knew at that point that he was lying.
I think you would have to infer that. I think I would even say it's a reasonable inference. They knew that he was lying, but we don't know it for sure. And the reason we don't is because there were some problems with the video evidence. It was a little off in terms of the time they had to adjust that. That happens at some point during the investigation. It isn't clear that they knew at the time of the grand jury that this witness they put into the grand jury was lying. But they certainly knew it by the time the trial rolled around.
So how does that cut? If they didn't know he was lying at the grand jury, how does that help you get over the Clemente hound?
Because by the time we get to trial, and we're dealing with what evidence is going to come in and what the jury's going to hear and what a fair trial looks like for William Shakespeare, by that time, they definitely know that he lied in the grand jury. So what trial counsel wants to do is let the jury hear that because that's the trial defense, and he's trying to give him a full third-party culprit defense that Mark Edwards, as opposed to William Shakespeare.
If I understand why you say Clementi doesn't rule. Is it because Clementi deals with sworn testimony under oath as a basis of admission, and you're not relying on sworn testimony under oath? You're relying on Chambers, Drayton.
Yes, I am. That's right. I'm saying it's out of,
We get out of the Clementi
we're out of that
world.
context.
Out of 801s, we're getting right into Chambers.
It's, I believe in terms of fundamental constitutional rights to a fair trial, we're way out of that. We're in Chambers territory. And I note that there's nothing in the Commonwealth's brief.
Which is
that
difficult for
adjusts-
you because it's a very narrow world of Chambers and Drayton.
But the chamber also, it is a very narrow world, but I also say Drayton isn't dispositive of this because of the nature of that testimony. You know, instead of dealing with like,
It's not the same, the general principle is that sometimes it's just so unfair, you get the hearsay to enable to allow a defendant to raise a defense. Drayton is one example of a Chambers case, correct?
and this is a completely different kind of example, so
And on
that's
your
why.
example,
Right.
I don't want to interrupt the flow of this, but on your example, I'm still stuck on why this is hearsay. Are you saying would be hearsay for the officer to say this is what he said? Or are you saying it's hearsay what I forget blanking on his name, and the grand jury said, Edward, what's his name?
So his name is Mark Edwards.
Mark Edwards.
Right.
So is what he said in the grand jury hearsay? Is that what you're saying?
Well, it's false exculpatory lies, so I would say that doesn't constitute hearsay, but in terms of the way the judge ruled, the trial judge ruled, and the basis for the trial judge's ruling, it was all argued and considered and came down to these issues of hearsay. And so, you know, but what I'm saying is, when you have a third-party culprit defense that you're putting on, and you have a constitutional right to put on a full defense, and you have lies under oath to the grand jury that are demonstrably false, and they're exculpatory, right, as to that person there, but we know that they're not true, the suspicion that falls upon that person, right, to the jury is very, very powerful.
So are you arguing that regardless of whether his statements are classified as hearsay, it still should have come in?
Because of the nature, yeah, because it's perjured testimony, and because he needs it to defend himself fully. It's evidence that is available to him, and he needs to have it.
So
And when
let's
his
just
defense is
say it's
third-party
not
culprit.
hearsay, because it's not being admitted for the truth of the evidence or the matter asserted. What you're saying, I think, is that it raises the substantial likelihood of a miscarriage of justice not to have allowed it, even though the issue was waived, because the credibility of Edwards was so critical to the third-party culprit defense.
Yeah, I don't think the issue was waived in the sense that.
Well, nobody argued it was not hearsay, did they? Did I miss that?
Yeah, I would argue that it is preserved as to non-hearsay in the sense that over and over again, if you go back and you look at the transcripts, the argument that's being made is that he's lied in the grand jury, this is complete lies,
But I thought
and
you
this
said
gets
that
in the
the-
way of my third-party culprit defense.
Okay, because I'm confusing that now with what you said about the judge framing it as hearsay and the arguments being all about hearsay. Are these two different arguments?
I think that they were both argued, but the only way that it was addressed by the trial judge was with respect to whether or not it was hearsay. But I believe that the record supports that both arguments were made.
Did the judge rule on the Clementi, on the Clementi issue? I'm sorry.
Yes.
No, I got it wrong. Did the judge rule on the Chambers issue?
No.
Okay.
And the Commonwealth didn't address Chambers in the brief either.
But, so Chambers wasn't brought to, even though Chambers in 1973 case, it's not brought to it's not the basis of the argument at trial either, right? Is Chambers raised at trial?
The case, Chambers, was, but the proposition of Chambers was certainly there. My client needs this evidence to defend himself, to have a full defense, a full and complete
They made
defense
a
that he's
Chambers
entitled to.
defense without,
I'm sorry.
so I apologize. They made a Chambers defense, but they didn't cite any authority for
But the
it.
Chamber's defense is there in terms of a right to a full and complete defense, that this is the
Right,
third
but I'm
party
just trying to
culprit.
figure out, the judge thinks this is a Clementi issue. It's being argued as a Chambers issue, but no one tells the judge, read Chambers, right? I know it's hindsight's easy, but is that right? Is that an accurate description of what's going on? The judge just doesn't realize this is a Chambers argument. He's applying Clementi.
Well, I think a trial judge with this level of experience, when trial counsel's saying to her, the grand jury testimony of the third-party culprit witness is complete lies, and that is very suspicious, and my client needs that evidence to defend himself at trial in order to exercise his right to a full defense, I do think that Superior Court judges that are presiding over murder cases should not need Chambers versus Mississippi to understand that that is a fundamental right and that he has the right to a full defense at trial. I think that
But
that
Chambers
was.
is a narrow exception to the exclusion of hearsay, right?
Did you say, which case?
Chambers is Chambers and Drayton, they're sort of narrow exceptions to the exclusion of hearsay.
So Drayton is narrow, and I would argue too that Chambers is not narrow.
The exclusion of hearsay, though.
Oh, to the exclusion of hearsay. Drayton is certainly narrow and very
I'm not,
fact-specific.
so let's just stick with Chambers, because as you
Yes.
say, that's your strongest case. So isn't Chambers about the exclusion of hearsay?
And it also, factually, it is about that, but it is about the right to put on a full defense. Okay, so we have a deceased witness, right? So that's how it ends up in the person is not available. And we have prior recorded testimony under oath. And we have a third-party culprit defense, not just a precipient witness, not just somebody who has a differing account to offer the jury. It's actually a third-party culprit that my client alleges is the perpetrator. So if you look at Chambers, what the actual holding of Chambers is, it's where constitutional rights directly affecting ascertainment of guilt are implicated, the hearsay rule may not be applied mechanistically to defeat the ends of justice, and if the evidence undermines the Commonwealth's case in a way that is indirect yet potentially powerful, that the defendant should be entitled to it. So if that's what Chambers says, I would submit that that's the controlling case that says that this trial did not align with what it should have aligned with in terms of his rights to defend himself with a third-party culprit defense, who was this witness who lied in the grand jury.
Can I ask you about Salemi?
Yes,
So we have, in the Salemi case, which is unique, we have Halloran, we have Salemi, and who knows who did what, right?
yeah.
But in this case, and it's in the light most favorable to the Commonwealth, because it's really a sufficiency issue, we have a beef between the victim and the defendant in a scuffle. We did not have that in Salemi. So isn't that enough to get the Commonwealth over the rail on the Salemi issue?
What I think is that if all of the evidence that should go into that calculus goes in, it doesn't. So what the Commonwealth was able to do, because of the trial judge's ruling on the grand jury testimony of Mark Edwards, the Commonwealth was able to argue to the jury that Mark Edwards was a completely forthcoming person who was totally cooperative, knowing that he had lied in the grand jury.
Well, it's an interesting issue because we're looking at it in a light most favorable to the Commonwealth based upon what was introduced. You're saying there was, I mean, obviously, if there was error in that big evidentiary
Right.
ruling, it's in your favor, but
Right.
assuming we don't, for sake of argument, we don't agree with you on the Chambers issue.
Yeah,
We have to look at the Salemi issue in a light most favorable based upon what was introduced. So address it that way.
It's tougher that way, however, I would say, there's 3 people out there, right? And Mark Edwards shows up 90 seconds before this guy is dead, right? And so, there's not no evidence, right, that makes Mark Edwards not suspicious. He comes in the back door, you have the barbers saying, one of them saying, he's worked there for 20 years, and that's weird for that guy to come in the back door because he'd
We've
never
got this-
seen him
we've got
before.
this-
Suspicious things.
But we've got this confrontation and argument and scuffle.
And we get the confrontation, we have the scuffle, and we don't know what happened. From, like, when I look at Salemi and, I look at Halloran and Pappas, all that guy that's sitting to the right looks pretty good for the thing to me, right? I mean, I get it that, no one really saw it. It looks pretty close to me. These are the 3 guys that are out there and no one saw it, right? And we're giving a lot of deference to the fact that in the Salemi case, there's pretty good inferences, right? That suggest one over the other, but we're saying we're not quite there. I'd say the same for this with the 3 back there, and no one saw it, and, you can't go on the positioning, because, Salemi tells us you can't go on the positioning like that because, they're neither
there was
close
that
range.
10-minute gap between the visual knowledge of where everybody was positioned, whereas here, what's the gap, or is that in the record?
So,
I mean, isn't the video
it's
actually
not a
capturing it
10-minute
in
gap.
real
So we-
time?
yeah, we have the video.
Yeah.
And it seems quick.
Okay.
Because they hear the gunshots and then, there's a reaction, some say they're afraid. They want to make sure, there's some quiet before anybody's going to go actually poke their head out there. But it's quick. It's not 10 minutes. But I'm not sure that the 10 minutes versus, let's say, 1 minute would be that distinguishing. It would be more, 3 people together, 1 dead, nobody saw it, 2 potential shooters would be more what the focus would be. Thank you.
Okay, thank you. Attorney Montgomery Lewis.
Good morning, Your Honor. Sarah Lewis on behalf of the Commonwealth. Before I begin, I would just like to acknowledge members of the victim's family who are in the courtroom with us today. We're asking this court to affirm the defendant's conviction for the murder of Marcus Hall. I would like to begin, if I may, by addressing the grand jury minutes and the judge's decision to exclude. And I would like to first talk about the record and just clarify some factual points. Mark Edwards's photograph was put onto a Boston Police Department flyer in the days after the murder. He then, seeing that or learning that his face was on it, turned himself in or voluntarily showed up at the police station and had a recorded statement to the police. He then did testify in the grand jury, and his testimony in the grand jury was an admission that he was there at the barbershop. In the minutes, or he said he was there that morning. The video would contradict exactly when he said he was there, the time exactly, but he said he was there. He said he did not see the defendant or hear gunshots, that he received a phone call and he left. And the video shows that he left the barbershop 90 seconds before the shooting. That was what he testified in the grand jury. At trial, the defendant filed a motion in limine to admit third-party culprit evidence. He did not put in that motion anything about these grand jury minutes. It was raised on the 6th day of trial that these grand jury minutes of Mark Edwards should come in. And I think what's important is to look at the defendant's offer of proof. He argued that it was admissible as prior recorded testimony, not hearsay, he said, and that he argued he would meet his burden and that the minutes themselves met the burden under Clemente, that the Commonwealth did not have a similar opportunity and motive in the grand jury. He then also argued that they were admissible because Mark Edwards lied when he was about being at the barbershop and not hearing the gunshots. But he did not specifically argue anything with respect to Chambers or this court's application of Chambers in Drayton. And ultimately, the judge's ruling was based on Clemente, although she also did respond to the arguments about whether these grand jury minutes should come in to show that Edwards was lying. And I think pointing out in her response to that was that we don't know his motive for why he said he didn't hear gunshots. We don't know whether that was a lie because of consciousness of guilt or for some other reason. And so that was the ruling. And I just think that that factual framework is important to lay out.
Can you go back just a minute?
Yes.
Because I missed your point about the cross-examination. I just couldn't hear it when you went through it.
About similar opportunity and motive, okay. So, and now I'll get to, the judge did not abuse her discretion in declining to admit these grand jury minutes as prior recorded testimony of an unavailable witness. The Commonwealth did not have a similar opportunity and motive, or the defendant did not meet his burden to show that the Commonwealth had a similar opportunity and motive in cross-examining or in questioning Edwards at grand jury as they would have at trial. And there are
Yeah, we don't have a Clementi issue. That's not being argued here. We have the Chambers issue. So can you help us as to whether or not the grand jury minutes would have shown consciousness of guilt of a third-party culprit or not?
Yes, and Justice Gaziano, I do understand that it's not, that the defendant's not arguing Clemente. That's what the judge relied on. And I would say that she properly analyzed it under that framework because these are prior recorded statements of an unavailable witness. And her ruling for that reason was proper. If we move on to the Chambers issue, I do also question, as you have, this is not hearsay. So how does these statements or the testimony come in as consciousness of guilt or effectively impeachment evidence under a constitutionally based hearsay exception? I think that's the first question. Is this even admissible if the point is to prove the falsity of the statements,
Right,
as
so-
Justice Wendlandt pointed out?
Why doesn't the grand jury testimony just come in then? Because it's not coming in for purposes of hearsay. That's what I'm struggling with, is why is this not just per se admissible? Because it's not hearsay.
Well, then I think then you would turn back, my understanding would be to the Clemente issue, because prior recorded testimony of an unavailable witness is a hearsay exception. And so,
But we don't need a hearsay exception because it's not hearsay.
and it's not, I mean, my understanding of Clemente is it's not considered hearsay under that analysis. That it's, and even the judge's ruling, she said, assuming that this is non-hearsay, it doesn't come in under Clemente because the Commonwealth did not have a similar opportunity and motive in the grand jury, and we did not have that. And I would say for two reasons. As my sister pointed out, I think it's unclear whether we knew he was at the barbershop. He's on the video. It's unclear whether the Commonwealth was aware that he might have been out back in the back parking lot at the time of the actual gunshots. He left the barbershop 90 seconds before. That's unclear, and I think that goes directly to whether we had a meaningful opportunity to attempt to contradict his statements on that point, meaning his statement, I didn't hear gunshots. I think also there's a question of motive. Trial counsel at trial argued that our motive in putting Edwards into the grand jury was to clear him as a suspect. And I think our motive was to determine who the shooter was. And we, at best, had, for the defendant's position, perhaps that Edwards was present, but that didn't have any bearing on culpability, particularly vis-a-vis the evidence against the defendant in this case. But I want the other. So I think it does raise a question here of whether this evidence is even admissible under Chambers in kind of dealing with that hearsay question. But even if we go to this constitutionally based hearsay exception, very rare, this court had strong language in Ying about the rare application of that hearsay exception. There's two criteria that need to be met. First, that it's critical to the defense, and second, that it bears persuasive assurances of trustworthiness. And I don't think that...
Keep talking about hearsay exceptions, and it's not hearsay.
I agree. And so then I think it doesn't come in. There's no way to...
Why wouldn't it presumptively come in if it's not hearsay?
I think because the If it's not hearsay, then I think you fall back under the Clemente analysis, and it's not admissible under Clemente.
Could it come in to show Edwards's character or truthfulness? I mean, we keep looping back around into Clemente, but I think there's other bases for admitting evidence, statements, than hearsay. Sometimes they're not hearsay.
And I understand that, and so I think the question is, to the extent it goes to consciousness of that it's admissible to show Edwards's consciousness of guilt, and let's assume that it should have come in for that, and I would not concede that. I think it's mere consciousness of guilt, balanced, or at best for the defendant, consciousness of guilt evidence, balanced equally against that it could have shown a fear of reprisal, any other motive for why Edwards said what he said in the grand jury. And I don't think it has.
Would you need a why? Do you need a why he said what he said? Or
No.
couldn't the defendant just have had it admitted?
I think there has to be a relevance, and I don't.
Well, it's assuming there's relevance because he's contradicting what he's told the police.
I understand, and I understand that, when you think about what the defense was here and that this related to his third-party culprit defense, but he had ample evidence and really consistently pursued his third-party culprit defense. He also...
I'm unclear. Did his grand jury testimony contradict his statement to the police?
No, it was consistent.
Oh.
I would say that and so I think that's the other question is, if it comes in as impeachment or consciousness of guilt, it's effectively impeaching the video. There's not a hearsay
So it's the video
declare.
that his testimony contradicts.
Arguably, the defendant's position at trial was that Edwards was outside in the back parking lot at the time of the shooting. The Commonwealth shared that position. Now, that's not a concession. That position that the Commonwealth took, that Edwards was out back at the time of shooting, is not a concession that Edwards, in fact, lied in the grand jury because he was guilty. That's the position we took in anticipation of the defendant's third-party culprit defense. But I think there's a question of how it comes in and its purpose. And even if it should have come in, the jury knew that Edwards was present out back.
What does the video show in regard to Edwards out back?
It shows a darker red. Let me step back to answer your question. The video shows around 2 minutes before the shooting, it shows Edwards walking into the barbershop and then getting a phone call and walking back out. Then, about 2 minutes later, the defendant walks in, and what's important is Edwards has a dark red shirt on, or a bright red shirt, and the defendant has a more muted burgundy type color red shirt. So you see 2 minutes after Edwards walks out, you see the defendant walk in, and the victim immediately approach him, and they go out together. And so now to answer directly your question, it is a grainy video with the camera pointing out to the back of the barbershop, but you see 2 red T-shirts out back. The Commonwealth's position is that you see the defendant's red T-shirt as he scuffles with the victim, and then you also see a brighter color of a red T-shirt in the doorway out back, which is arguably Edwards.
All right.
But you do not see his face.
And then the gunshots happened then?
Yes. At that, so I would say, and this goes to the sufficiency and looking at Salemi, this is not a case where there was an equal opportunity with respect to both the defendant and Edwards. It's a case where the Commonwealth proved beyond a reasonable doubt that it was the defendant. The defendant and the victim scuffle or have a physical altercation at the back door to the left of the door.
On this whole issue of the grand jury testimony, don't we have to take the evidence as the Commonwealth argued it, that being that, and I get the Salemi argument about who had the beef and who didn't have the beef, But on the grand jury issue, don't we have to take the evidence the way it was presented to the jury by the Commonwealth, that Edwards was there at the time of the shooting?
Yes.
Which is inconsistent with his grand jury testimony and his statement to the police.
Yes, that would be inconsistent. Sorry.
Did his statement to the police, did that come in at trial?
Portions of it, but not the statement itself. There was testimony of Sergeant Detective Stratton by
I
both
didn't
the
want to interrupt
Commonwealth.
too much, but I just needed to get that. So
Yes,
Go ahead.
so that came in, and we do need to take the Commonwealth's position. I will say there was Sergeant Detective Stratton off. This initially came out. The Commonwealth opened by suggesting, yes, Edwards was back there. He was one of the two sets of unidentified legs back there. But Sergeant Detective Stratton's testimony, which initially the defendant, I would say, opened the door to on cross, that was Edwards back there. That's my opinion. I can't say for sure. But yes, that was the position the Commonwealth took. But in terms of whether Edwards' police statement, what exactly came in and other third-party culprit evidence that came in, because I think that's crucial here. The jury heard.
The big Drayton point that the defense counsel would be making is that he lied that he wasn't there at the shooting. That's the.
Yes.
And the question is, does that meet the Drayton standard? Although Drayton's hearsay, this isn't hearsay,
Right.
That's right.
And look, I've considered this, and I've struggled with that question. I mean, looking at under Drayton, you're looking at whether it's critical to the defense and whether it bears persuasive assurances.
Is there any other evidence that makes that duplicative? Go ahead. Yeah.
So, I didn't want to cut off your question, but that's where I was going to go in terms of what other evidence was before the jury. The jury heard that Edwards, when he went to the police station, he turned over his cell phone, voluntarily agreed to turn it over, but said, I erased all the contents because I sell weed. So that, to the extent that's consciousness, well, not to the extent, that's consciousness of guilt evidence that was before the jury. And I would argue powerful consciousness of guilt.
Mine's a different question,
Yeah.
more narrow.
Okay.
From what I gather from this, although I don't fully follow it yet, is that the missing information is Edward lied that he wasn't there at the shooting. Is there other evidence of him lying about that? Is there something that's admitted that makes that point duplicative?
No, not that point. But again, at best, it's consciousness of guilt evidence. And that's not enough. That mere, let's call it impeachment evidence, is not enough to raise a reasonable doubt where there was other consciousness of guilt evidence before the jury in terms of him wiping his phone clean. And then also, there's no dispute about him being present. That was before the jury, and the defendant pursued it consistently, thoroughly, vigorously, as the motion judge, who's the trial judge, discussed in her opinion. She said, experienced trial counsel mounted a consistently aggressive challenge to the Commonwealth's theory Shakespeare was the shooter in this case via both third-party culprit doctrine and a Bowdoin challenge to the Boston Police Department's investigation. That was all thoroughly before the judge, and I think, the jury, I'm sorry. And if you look at that, and then take this evidence, I don't think you can say that the fact that Edwards said he did not hear the gunshots or did not see the defendant in the grand jury is critical evidence that would have bolstered those defenses given what else the defendant put forth before the jury. If your honors have no other questions, I would just say that the defendant should not be granted any relief.
So address the Stratton testimony about the video briefly.
Yes, there was no error in the admission of that testimony. I think while it wasn't, I think the motion judge's decision, again, the trial judge, on the ineffective assistance of counsel claim does address this very well, insofar as identification was not at issue. The defendant's position was that he was at the back door at the time of the shooting. It was just that it was Edwards who pulled the trigger. So this is not inadmissible identification testimony.
Stratton's identifying him as fighting with the victim, right?
Yes.
Through the video.
Yes, and that came out on redirect examination. After, that did not come in on direct examination in terms of Stratton's observations of that altercation. It came out on redirect after, I would say, the defendant opened the door to it on cross-examination. He, on cross-examination, asked about Edwards being out back, whether Sergeant Detective Stratton saw a firearm in his hand, in Edwards as that is, asked about his grand jury test, what Stratton testified in the grand jury, and so what then ended up coming out on redirect was in response to that. But I would say that in any event, it was not error, because as Judge Roach specifically found throughout this questioning that the Commonwealth did, was that the testimony regarding the video went directly to the state of the investigation, which was, and directly to the Bowdoin defense that the defendant was raising. And she gave a clear and forceful instruction on that point, and how it was ultimately up to the jury to decide what the video showed. So I would say there was absolutely no error in what Sergeant Detective Stratton testified to, and what was admitted at trial in terms of what he saw and observed on the video. The court has no further questions. I would say that the evidence was sufficient as to both deliberate premeditation and extreme atrocity and cruelty, and the conviction should stand. Thank you.